Hello and welcome November 4th, 2023. We have no regrets this evening. All of us are here, virtually or otherwise. And Council, are there any declarations of pecuniary interest? Madam Clerk, I see no declarations. Would a mover and seconder like to put us into committee of the whole? Councillor Lischina and Councillor Dudek, thank you. Any objection? There being none, that carries. And we are resolved. Council and public, items 7.5 and 8.3 on the agenda under section 2, sub 10 of the procedure bylaw have been postponed to a future meeting. On our consent items, we have two items. One is a notice of intention to demolish at 1312 Lakeshore Road East, and the other is the Preserve Phase 2 partial subdivision assumption. And staff are available if you have questions. Otherwise, I would entertain a motion to adopt the consent items. Councillor Dudek, you were first out of the gate. Thank you. Any objection? There being none, the consent items are adopted. Now we have a confidential consent item, and this particular one, staff expect that you may not need to go into camera. I'm prepared with a resolution for you if you do. And the indicated motion is in the agenda. Council, are you prepared to adopt the indicated motion, or do you need to go into camera? The best way to answer is to move the indicated motion, if that's your pleasure. Councillor Adams, thank you. Is there any objection to the motion? There being none, that carries. The motion is that staff be authorized to proceed to the Ontario Land Tribunal in respect of an application for a zoning bylaw amendment applicable to 106-114 Robinson Street and 71 Water Street, in accordance with the recommendations of the confidential report from the legal department dated November 21st, and that the town solicitor and the Commissioner of Community Development or designates be authorized to negotiate a settlement of the appeal if the applicant is interested in doing so, in accordance with the recommendations of the confidential report from the legal department that I just mentioned. That brings us to our four discussion items. The first one is the consideration of objection to notice of intention to designate, and that being the Turner House at 356 Watson Avenue, an item we deferred the last time it was before us to secure improvements to the language. And I have no delegations listed on this item, and so I'll look for a motion. Councillor Giddings, thank you. Is there any objection to Councillor Giddings' motion? There being none, it carries, and the motion was that the notice of intention to designate the Turner House at 356 Watson Avenue under Section 29, Part 4 of the Ontario Heritage Act be maintained despite the notice of objection received from the property owner, and that bylaw 2023-129 to designate the Turner House at 356 Watson Avenue as a property of cultural heritage value or interest attached as Appendix B be passed. Now, Council, we have a recommendation report on the official plan amendment and zoning bylaw amendment at 115 Trafalgar Road. We have a presentation from Kate Coburn, and we have a representative of the applicant available for questions if wanted. And at this time, I recommend we all give our attention to Ms. Coburn.
Thank you very much, members of council. There we go. Thank you, Mayor Burton, members of council. Before you this evening is an official plan amendment and zoning bylaw amendment, which has been submitted by Bouse Fields, Inc. on behalf of their client Trafalgar Luxury Living, Inc. The proposal relates to the replacement of an existing 2-story commercial building with a new 6-story mixed-use building in downtown Oakville. The report can be found as item 7.2 in tonight's agenda, and the purpose of tonight's meeting is to provide a recommendation to council to make a decision on the applications. The subject land is located on the southeast corner of Trafalgar Road and Church Street in the downtown Oakville growth area, and it is immediately west of one of the town's parking structures. The applicant is proposing to replace an existing 2-story commercial building with a new 6-story mixed-use building that includes 12 residential units, 3 commercial units totaling approximately 230 square meters, and 1.5 levels of underground parking to accommodate a mechanical lift system. The applicant requires the official plan amendment to permit an increase in height from 4 stories to 6 stories, and they require the zoning bylaw amendment to change the zoning from the CBD or Central Business District zone to the mixed-use zone MU1 Main Street 1, with special provisions that will reflect the proposed development. The subject land is designated as Main Street 1 with eligibility for bonusing in the official plan, which permits mixed-use buildings to a maximum height of 4 stories. The eligible for bonusing overlay would have permitted council to consider an increase in height to 6 stories without amendment to the plan. With recent provincial changes, the Section 37 bonusing regime is no longer applicable, and therefore an official plan amendment is required to increase the height from 4 stories to 6 stories. Together with this special exception, the mapping will be updated for the subject lands to remove the eligible for bonusing overlay. The bylaw and official plan amendment have been included in Appendix D of the staff report. As mentioned, the existing zoning on the property is Central Business District, which provides regulations for a range of uses and permits a mixed-use building to a maximum height of 4 stories or 15 meters. Staff have reviewed an application to propose a new 6-story building with 12 residential units and 3 commercial units, but has also modified the applicant's original proposal to change from CBD to MU1 with special provision 427. The MU1 will align the zoning with the official plan designation. This bylaw is included in Appendix E of the staff report, and the modifications to the bylaw include an increase in height from 4 to 6 stories, as well as an increase in height metrically from 15 meters to 23 meters in height. There are also additional setbacks for the 5th and 6th stories. There are modifications to parking dimensions and the parking counts while maintaining a total parking amount of 21 parking spaces. And there are also holding provision that has been included with this application to allow staff to further review an environmental site assessment for the region of Halton, as well as servicing capacity at the Navy Street transfer facility. In addition to that, transportation impact study and a parking report to better understand the location of the access and the proposed parking mechanical system. Additionally, staff have evaluated the impacts of the proposed additional 2 stories and have provided specific regulations in the zoning bylaw to implement additional step-backs in the building to address massing and access to light. The figure that's noted here is included in the zoning bylaw and prescribes the various points of height changes and step-backs that would be accommodated with the proposed development and implemented in a future site plan application. With respect to public consultation, the applicant had a virtual public meeting earlier this year on February the 2nd. The application was submitted on August the 10th of this year, and the statutory public meeting was held October 16th. Since the writing of this report, 4 public comments have been received, which does include 1 objection, which was heard at the public meeting. And the items of note on this slide reflect the questions and concerns raised by the public to date, which included access from Trafalgar Road, the height of the building, traffic on Trafalgar Road, and public benefits as a result of Section 37 no longer being applicable. It's a very busy slide. In addition to the items raised by the public, the following slide highlights the matters to be addressed, specifically the matters raised by staff in the public meeting report on the left side of the screen, and the items raised by council at the public meeting on the right side. These items have been thoroughly discussed and evaluated in the staff report, which is found on pages 30 to 35 of tonight's agenda. Staff are satisfied that the proposed development is consistent with the provincial policy statement and conforms with the growth plan and the Halton Region official plan, as well as the town's official plan. It has regards for matters of provincial interest and represents good planning. Further, the application is consistent with the town's approved urban structure and the principles and overall policy direction of the Livable Oakville plan that supports growth within our defined growth areas. It is staff's opinion that the proposal implements the vision, development objectives, and community design strategy and land use strategy of the Livable Oakville plan, and that functional and technical design matters will be fully addressed through the future site plan application, including resolution of the matters included in the holding provision. In conclusion, Your Worship, staff put forward the recommendations shown on the slide for Council's consideration, and it is staff's opinion that the applications for official plan and zoning bylaw amendments be approved to permit the development of a 6-story mixed-use building with 12 residential units and 3 commercial uses on the ground floor with underground parking at 115 Trafalgar Road. Thank you.
Thank you, Ms. Coburn. Council, if you have questions or comments, now's a good time. We have no registered delegations on this file. Councillor Ilger.
Thank you. Through Mayor Burton to Ms. Coburn. Interesting when you started talking, and maybe you can explain a little bit more. You mentioned, first of all, hydraulic lift, which I'm thinking, you don't hear that very often. Then later on you said proposed parking mechanical. Could you maybe explain maybe to what you're really saying there, what it is, what's different in this building from the normal buildings?
Through you, Mr. Mayor, to the councillor. So the reason for the holding provision is exactly that, councillor. We're trying to understand the mechanism in which they would be applying the technology, whether it be through some mechanical means or hydraulic lift, in order to stack the parking spaces that they've proposed to be accommodated within this building. We need to understand the depth of the underground structure in order to accommodate the hydraulic lift to ensure that it's sufficient, as well as understanding how the parking spaces themselves or the vehicles that would be using this are to be defined on a per unit basis.
So for the commercial, they wouldn't be part of that? It would just be for the residential, I take it?
Through you, Mr. Mayor, the commercial parking standards are 0 in the downtown due to the variety of on-street and municipal parking lots that are available within the downtown. However, there are 3 visitor parking spaces that are also to be further evaluated to understand their opportunity to be included within the public parking allotment available within the downtown for the property.
But those 3 would not have the hydraulic or the mechanical lift?
Through you, Mr. Mayor, that's what we will be looking to ensure.
Perfect. That would scare me a bit. Thank you.
Thank you, Councillor. Councillor Lischina.
Thank you, Your Worship. I had the same sort of follow-up on those questions. Do we have other examples downtown or anywhere else of buildings who are using the hydraulic or mechanical, and have we any key learnings from that?
Through you, Mr. Mayor, to the councillor, that's an excellent question that we can definitely look into through the review of the transportation impact study and the parking component of that. That's included in the holding provision of the bylaw.
Thank you, Councillor. Councillor Giddings.
Yeah, thank you. Through you, Mr. Mayor. 2 H's on the proposal. One for potential site contamination. The second is for servicing capacity. No, it's a regional question. Are we that close to the line at the Navy Street pumping station? I was surprised to see the H in there for that.
Through you, Mr. Mayor, to the councillor, that is an excellent question, and as well to be resolved through the lifting of the hold and the documentation the applicant will need to provide to the region to satisfy that. But my understanding is that they need to verify what that capacity is in order to support this intensification on the property.
Understood. Thank you.
You're welcome.
Thank you, Councillor Giddings. Councillor Haslett-Deal.
Happy to move it, Mayor Burton.
Thank you, Councillor. Is there any objection to the motion? Madam Clerk, there being no, I'm going to take it that the hands that are up are not objecting. That carries unanimously. Thank you, everybody. Councillor Haslett-Deal. Councillor Adams.
I believe we're up to item 7.3, and I was going to suggest that I would move the staff recommendation unless staff have some new information. There's been little discussion on this item, and I think it's appropriate to move it.
Thank you, Councillor. The chair appreciates your assistance. Councillor Adams has moved 7.3, which is the recommendation report for the zoning bylaw amendment at 2360 Bristol Circle. Is there an objection to the motion? Madam Clerk, there being no objection, Councillor Adams' motion carries. This is that the zoning bylaw amendment application submitted by the Caniff Group as revised be approved on the basis that the application is consistent with the provincial policy statement on planning, conforms or does not conflict with all applicable provincial plans, conforms with the Region of Halton official plan and the Town of Oakville official plan, has regard for matters of provincial interest and represents good planning for the reasons outlined in the report, and that the bylaw, an amendment to the zoning bylaw to give this force and effect be passed, and that the notice of Council's decision reflect that Council has fully considered all the written and oral submissions relating to this matter, and that those comments have been appropriately addressed, and that in accordance with Section 3417 of the Planning Act, no further notice is determined to be necessary. Council, 7.4 is now before us, and that's the noise bylaw update. And Selena Campbell has a presentation to which I invite everyone's attention. Ms. Campbell, welcome. We look forward to this.
Perfect. Thank you, Mr. Mayor. So thank you and good evening, members of council. I'm here with Craig Williams, Strategic Business Advisor with Municipal Enforcement Services. Craig he's leading our bylaw review, and Craig has also been, you may recognize him, he has been a municipal enforcement officer with us for the last 30 years. So now he's working as a strategic business advisor for us. So the Municipal Enforcement Services Department conducts periodic reviews of bylaws to ensure legal compliance, relevance, clarity, adaptability to changing circumstances. Now, the noise bylaw 2008-098 is over 15 years old, and it no longer adequately reflects the current community expectation, noise control guidelines issued by the province, or recent changes to the Municipal Act that has changed our authority and the authority for municipalities to regulate and control noise. When considering noise regulations, it's important to understand the applicable legislation. The Municipal Act empowers municipalities to pass noise control bylaws. The province regulates industrial noise sources through the Environmental Protection Act. And if a municipal bylaw conflicts with provincial guidance, the EPA guidance prevails. So it's important to note that as part of the provincial COVID-19 recovery plan, excuse me, the Ministry of Municipal Affairs and Housing introduced regulations that came into effect on September 19, 2021, that removed the municipality's authority to regulate noise related to the delivery of goods for all retail businesses, restaurants, hotels and motels, and good distribution centers. Our personal experiences and biases and perceptions inform our opinions regarding the sound versus noise relationship. So for example, when I use a snowblower, it makes sound. When my neighbor uses a snowblower, it makes noise. When my neighbor uses a snowblower to clear my driveway, it sounds great. So it really depends on our perceptions. Now, noise is often defined as an unwanted sound. So sounds from a vibrant urban activity compete against that desire for quiet enjoyment of indoor and outdoor living spaces. The goal of this review is to develop regulations that strike a reasonable balance between these two opposing realities. Now, this slide has been included to provide an understanding of the relative relationship of sound by depicting them on a decibel scale. The decibel scale is a logarithmic or exponential scale. Think of the Richter scale for earthquakes. The scale was chosen because human perception of loudness is also roughly logarithmic. So as an example, the difference between 50 dBA and 60 dBA wouldn't be perceived as 20% louder. Instead, it would a 10% decibel increase would actually be perceived as twice as loud. So the logarithmic scale allows us to depict very faint and very loud sounds on a scale, on the same scale in a more meaningful way. So the existence of noise bylaw implies a shared understanding and agreement within a community that controlling noise is necessary. Noise bylaws acknowledge the rights of individuals engaging in activities that create noise, while recognizing the rights of others to a certain level of tranquility. By involving members of the public, in the consultation phase, a sense of ownership is fostered that reinforces the idea of that collective agreement. So not all noise can be controlled. Noise from airplanes, trains, boats on the water, infrequent and delivery noise associated with restaurants, grocery stores, and warehouses cannot be controlled. A bylaw that attempts to deliver all things to all residents, regardless of the situation, is not economically feasible. Bylaws should include standards that are fair and have a reasonable chance of being upheld in court and are enforceable while considering staffing resources. The current comprehensive noise bylaw has indoor noise thresholds that are the same as outdoor evening noise thresholds. So this is one of the changes that's in the draft. And those are set at 45 dBA. The guidelines offered by the province of Ontario suggest that a 45 dBA for outdoor limit only. So it doesn't really address that indoor threshold. So no indoor limit has ever been provided under the provincial guidelines. In order to address this, staff considered a significantly lower indoor threshold based on research such as that conducted by the World Health Organization, field testing, and collaborative discussions. In addition, a new bylaw provides greater consistency in those noise and time limits. So in April of 2022, staff launched a public notice or public noise questionnaire. Approximately 1,500 people responded to that questionnaire. The final question invited residents to provide additional written comments. That opportunity really elicited 800 additional comments that were provided by the participants. Comments varied greatly, but the questionnaire appeared to be successful, even for those who noted that we didn't address their concerns. We can assure you that staff read every single comment that was provided, which is why we know that further consultation is required. So highways are governed under the Highway Traffic Act, the HTA. The HTA contains noise regulations which are enforceable by police. Municipal enforcement officers have no authority to stop a vehicle on any highway. Currently, there is no practical, quantifiable decibel standard for automobiles. The Society of Automotive Engineers has J2825, and it's a standard for testing noise from motorcycles only. And that is the standard used by Oakville and other Ontario municipalities. Now, we've all heard a lot about leaf blowers over the years, and domestic power tools were looked at. They're a broad category and are defined within the provincial noise guideline, the NPC 300. The guideline informs us that these devices are not considered a stationary source of sound. So they are really, they're to be addressed in a qualitative manner rather than, measuring that sound quality. Staff are not recommending any changes to this category. We are, however, recommending that domestic power tools that utilize small gas-powered combustion engines be considered as part of an environmental review being conducted by the town's Strategy, Policy, and Communications Department. Further public consultation is required to allow staff to seek clarification on comments provided and to provide the public with the draft bylaw for comments and suggestions. This final public consultation phase will enable staff to address issues prior to presentation of a new bylaw to council. And we are here to answer any questions you may have.
Well, if you wanted questions, you've hit the jackpot. There are a few. We'll start off with Councillor Ray Chisholm.
Thank you, Your Worship. A couple of questions. Let's go back to the motorcycle vehicle. In page 121 of the 164 report, it talks about increased level of concern and complaints from the public. An intergovernmental brief has been forwarded to the province. Do we have any feedback on that report from the government? I direct that to staff. Through you, Your Worship.
Counselor, they're working on it.
Through you, Mr. Mayor, if I might be able to help with that. The intergovernmental brief has been prepared for council to use for informational purposes. It's part of the package with other informational briefs. So if you are speaking to the province at any time, that brief provides you with the information to ask questions and find out why the province has decided not to provide similar enforcement mechanisms for automobiles as they have for motorcycles.
So, but I'm reading it's been forwarded to the province. Is that incorrect?
Through you, Mr. Mayor, I would say yes, that hasn't been forwarded to the province. It has been created for council.
Is there the attempt to send this off to the government with respect to the concerns of motor vehicle noise?
Through you, Mr. Mayor, what I would say to that is the intergovernmental brief wouldn't be the tool, but there are tools that we could prepare, and when we come back with the final version, we could bring back a tool that would be more suited to that.
Thank you. Next question with respect to the advanced noise monitoring systems. Is there anything on the market that we can utilize to improve our measuring of the noise on motorcycles and vehicles?
Through you, Mr. Mayor, currently New York City is using 14 of these devices successfully to issue tickets. So they started off with a pilot program using 2 of them. It's like a radar-based system that you would use for speed enforcement, but it's for noise enforcement, so it can pinpoint the vehicle that drove by and the level of noise they were at a known distance, and then it will issue tickets, no different than what our automated speed enforcement does. So similar system.
So that's something that must be new, because the concern at that one time with on the monitoring part, we had to do it stationary, and it really didn't give us a good indication on the noise level. But now you're saying moving vehicles can be measured?
So what we're saying is in that intergovernmental brief, we're asking the province to consider adopting that technology so that we, in the HTA, so that we can utilize it in the town.
Good, thank you. And my last question is with respect to the leaf blowers. The point was taken that we're not going to be doing anything on leaf blowers, but can we have some discussion or comments with respect to the number being used on properties? I would assume as they are domestic tools that we're using, most of us, who have one might only have one, but when you have landscape services and so forth, there's a brigade going out, 4 to 6 leaf blowers going at once. Is there any discussion with respect to limiting the use of those and the maximum number you can use per property? I know that's a heavy question on this one.
We didn't approach it in that vein. We looked at it as an individual use, but we can certainly take that back and take a look at it as well.
Yes, I think that's important, because there's a lot of properties where landscaping services come in with 4 or 5 workers with on their backs doing it at the same time. So something to consider.
Through you, Mr. Mayor, if I could also respond to that, I would caution that is something that we might want to look at through the environmental portion of this. We have to be cautious of the noise bylaw, which is specific to noise. So we don't want to cross the 2 over, or else we'll have an unenforceable bylaw. So I would say that I think the appropriate process to take is to include the environmental piece, or the multiple leaf blowers or other small equipment in that strategy, policy, and communications piece.
Jim, I totally agree with that, but when you put 4 to 6 of those machines going at once, the noise level decibel does go up exponentially. So I just have some consideration for that in the future. Thank you.
Thank you, Councillor Chisholm. Councillor C.
Thank you, Mr. Mayor. So I have a question for the further public consultation. So is any that includes the meeting, online survey, Fox groups, anything else you plan?
Thank you. Through you, Your Worship. Definitely further consultation will include likely another questionnaire, as well as outreach to those who have participated in the survey. We do have a number of individuals who have specifically expressed their desire for us to contact them. We'll make sure that they have all been contacted and have an opportunity to not only review the bylaw, but provide any comments on that as well. So there will definitely be outreach.
Okay, so that will be different design about the online survey.
Correct, there will be different, yes. There will be an online survey as well as specific email outreach and likely an additional public information meeting.
I see. Is any scheduled the meeting in January next year?
We haven't scheduled meetings at this time.
Okay, thank you very much. Mr. Mayor, so I would like to move this item after my colleagues finish their question. Thank you.
Thank you, Councillor. I appreciate that. Councillor O'Meara, it's your turn.
Thank you very much, Mr. Mayor. Just a few questions. The column on page 135 of our report, it states the operation, item K, the operation of solid waste bulk lift or refuse compacting equipment. Can you tell me what that is? I don't understand what that is.
Through you, Your Worship, that would be trash compactors.
Okay, so that's not meant for residential, that's meant for commercial then, or?
Correct, that would be commercial use.
Commercial use, okay. So we do have the ability to bring our noise bylaw in for commercial uses then, is that correct?
Sorry, through Your Worship, I'm just going to add to my previous, so it could also be for residential apartment buildings. But I can let Craig speak further to the commercial and industrial use because it does get a little bit more complicated in that fact because they are covered under an easer. So I'll bring him forward if you'd like more information on that.
I do, but maybe while he's up there, I can ask my second question because I'm sure he might want to speak to that one too. It's with regards to a lot of the issues we've been having on Spears Road. That buttress, the residential area. We've got garbage pickup happening at 5 in the morning, 5:15 in the morning, nonstop. We have had bylaw nonstop, tracking it, video evidence, everything. We don't seem to be able to limit that happening, which backs onto residential neighborhoods. So are we able to use this item to sort of rein in that and when pickups happen before on a Saturday or Sunday morning before 6 a.m. in the morning that residents have to do? Is this all one and the same, or is it something separate? And maybe I'll let Craig speak to that.
So through you, Mr. Mayor, the first question, just to answer, we've separated residential noise sources from commercial industrial for various reasons, mostly because the province made it very difficult for us to have one standard across Oakville that would be able to apply to all those sources. So the sound sources, which in your package revert back to only a residential source of noise, that most of the bylaw you see in front of you applies to that. We have made provisions in our bylaw if called upon to have to investigate a commercial industrial entity, that we will use the standards that are set out in MPC 300. And part of that is their ECA and EASER registration says that they have to comply with those regulations. So if we were to go and do a test on a commercial industrial partner in town, we'd be using those standards, the ones that are in MPC 300, because they're site specific. So one site in Oakville might have lower thresholds than another site. So we can't put in our bylaw a standard set of regulations that apply broadly across the town. So we had to separate those two out. So we can still do that, but I draw your attention to MPC 300 where it says the regulatory authority in commercial industrial entities is the province. So first and foremost, they have a hotline that they've encouraged us to tell residents to utilize to forward their complaints through that system. The bylaw still gives us the opportunity to go out and enforce our bylaw using those standards. Your second
Okay,
question.
I guess I
Sorry.
guess sorry, are you finished, Craig? I didn't mean to
No,
interrupt
go
you
ahead.
there. I guess my concern is that, you know, when residents are going through this on a Saturday morning, they don't have time to call a 1-800 number to contact the province to hope that they get somebody who's going to deal with it. They look to town staff and bylaw official to come and to enforce noise concerns that they have. And I guess my question is, what can we do from a residential area within X amount of feet from that area, whether it's commercial or not? Do we have the means with which to enforce those areas that buttress residential and commercial or industrial interfaces and ensure that those industrial or commercial areas are meeting a standard that we're going to adhere to regardless of what the province is saying or not? Do we have those mechanisms, or those are we legally allowed to do that or not?
So through you, Mr. Mayor, you were provided a document in that package that showed how a noise investigation takes place. And it's a 2-page document. These are very detailed investigations, and they don't happen on Saturday morning when a resident calls and says that they want enforcement. That kind of noise where we have to take a measurement reading and know whether or not they exceed the allowable limits are time-consuming investigations, and are not the kind of investigation that an officer shows up and says, shut all this down because we have a complaint. The mechanism we have in place. These investigations will take time. We'll come to a resolution. We'll give the opportunity to the industry to mitigate what it is that's causing a problem, to find a solution, and work through that process. And that will be similar to what the province would do. They would also put an order on the company and tell them to come into compliance within a certain time frame. But it wouldn't be an immediate shutting down of whatever it is that was causing the resident a problem. We don't have that authority, the ability to do that. We have to establish there's a violation, and then we have to give them time to comply.
So I guess my question is, we have the ability to set a line though, and say whether you're violating it or not. I know the investigatory process is long and doesn't happen immediately, but we have a line that we draw. And if we find conclusively that they have violated that line, we can prosecute. We have that line though for industrial and commercial that backs onto red. We have a line though, do we not?
Yes, we have a line and the province has a line.
Okay, I'm happy that we have a line, but when you keep defaulting to the province has a line, we get this shared responsibility where I'm not really sure who's responsible for enforcing this. So are we responsible for enforcing that line, or the province?
The province has indicated they're responsible for enforcing it. However, there have been incidences where the province has not taken corrective action in a timely manner, where our staff have been involved in gaining some sort of mitigation by doing our own testing and laying our own charges. So that has happened. We've had where certain companies have had both a provincial thrust and a municipal thrust on them. 2 different charges, 2 different bodies investigating them.
Okay, so what I would ask then as we move forward in this process is how we get some sort of streamlined accountability here for who's responsible. And if that is too convoluted, which I'm getting the appearance it may or may not be, how we communicate clearly who's responsible for what line of accountability here, because it's been at least 10, 15 years I've had the same residents complaining about the same areas, and they've just said nobody's doing anything. And if we can bring in more teeth into our bylaws, which can assist our residents when something as simple as garbage pickup at 5 in the morning on a Saturday happens for months at a time, we have the ability to pursue that. If we can proceed with that, that would be great. I would greatly appreciate that. So I'll leave that to you guys to move on. My last question, Mr. Mayor, is just with regards to the operation of construction equipment other than in connection with residential renovation, that line of argument. We have a number of developers who buy their own places, put it in a family member's house, renovate, and then flip it and sell for Tarion related beneficial regions and other reasons. Is there a way that we can add on to that? If there's an active building permit on the location, that wouldn't be excluded from that bylaw? if somebody's bought the house, but they're obviously doing construction there to flip it and to sell it, but it's their residential unit, is there a way that we can clamp down on that?
Through you, Mr. Mayor, we'll look into that for you, Councillor.
That would be great. Thank you very much. Thank you, Mr. Mayor.
Thank you, Councillor O'Meara. Councillor Haslett-Deal.
Thank you, through you, Mayor Burton. Thank you very much for the presentation. I won't go on about how we are going to need your help with a set of warehouses that may get built and the noise that may get caused. But I wanted to understand this qualitative measure that Councillor Chisholm raised around the blowers and why it would be in the environmental next step versus in the noise. Could you just give me a little bit more clarity, because in certain pockets it is unbelievably loud, and I don't even think the decibel levels are on your chart, how loud it really gets. And so I'm wondering, why is it qualitative? Why do the environmental, how can we, is there any option to regulate?
Through you, Mr. Mayor. So MPC 300 guides us with respect to domestic power tools. They don't consider them a stationary source, and a stationary source has noise limits. There are no quantifiable noise limits we can apply to a domestic power tool at this point. There are none that exist that are recognized. So we are left with quantifiable limits, which are time limits. Now, that being said, staff recognize that gas-powered combustion engines are much louder than a battery-powered unit, like for like, which is why we're saying that if you're going to review these dirty emitters on an environmental policy, that you consider the noise as part of that contaminant when those things get reviewed at the strategic policy review. But to use a noise bylaw to deal with an environmental issue it's just patently incorrect. You can't do that. And so our hands are tied because we don't have limits we can apply to these things. We don't have a testing procedure for them. We don't know how long we're supposed to measure them for. Is it 5 seconds? Is it 5 minutes? Is it 20 minutes? So there's nothing available to us at this point to be able to rely on.
So there's no provincial standard that puts it into a classification that allows us to do that, is what I'm hearing you say.
Through you, Mr. Mayor, that's correct.
Okay, thank you for that clarification. So I just want to make sure I understand 1C. So if I put a Sonos or a Bose speaker or on my phone, attach my phone to it, is that considered allowed, and at what decibel level?
So it is allowed during the day in the allowable hours, which we're suggesting is 7 to 7, which would be 50 decibel, right on an adjoining property, which is the allowable limit for air conditioner units, pool pumps, a number of other items. And then after 7 p.m., these items get treated differently than a lot of the other sources, which will still have a noise limit through the evening and overnight. They become what is considered to be an unreasonable noise, and then the test becomes the more restrictive test of clearly audible for all intents and purposes. So you go from being able to have a 50 dBA tolerance on someone's property to not being heard at all, basically, after 7 p.m.
All right, thank you for that clarity. Was there any consideration for a shorter period to get a noise exemption? So right now it's 30 days. And I've had some feedback from residents that they feel that that's, a long period of time. So something comes up, they want to do a celebration. They've got to go and they understand they have to check with the neighborhood. They have to go online and file. Is there a way to do it faster than 30 days and still meet your requirement of, and an important requirement that they've spoken to their neighbors and their neighbors are okay with it?
Through you, Your Worship. That certainly has been a consideration in the past. It's something that has been brought to our attention, and recently, with respect to filming, that was brought before council, and a policy was approved that shortened the time frame. However, the restriction really comes from our public engagement policy, where we really have that 2-week consultation period. So that really is a standard that's set throughout the corporation. It's difficult to not have that simply because there's delivery time, there's time to receive the comments back, and time for staff to consider those comments in a meaningful way, where we can look at ways to mitigate sound and that sort of thing based on the comments that are received. So it's certainly something that we can take back and further review, but there will be challenges with reducing that time frame.
All right, thank you for that clarity. I have just 2 last questions. In terms of identifying background sound in your measurement, is that following what the provincial guidelines are in terms of identifying what background noise is?
Through your worship, short answer to that, yes.
Okay, thank you. I just wanted to know which resource to direct some people to. And my last question, and I'm not sure it comes to you, it might come to another staff member. Is the strategic business unit going to do the environmental review on domestic power tools in 2024?
Through you, Mr. Mayor, I understand that it is in 2024, yes.
Okay, and that would include opportunities for some form of, it's well written in the report. It's an excellent presentation and report. It will include an educational component so that those that don't understand the implications of gas versus using battery versus electric, and how it could be more neighborly if they choose at some point to change their equipment. Will it include all of that?
Mr. Mayor, maybe I can offer to have our strategic policy and communications unit send a memo to council describing what that review might look like.
Thank you very much. That'd be appreciated.
Thank you, Councillor. Councillor Dunick.
Thank you. Through your worship, I wonder if we're going to be doing additional surveys or public opinion polls. Would there be an opportunity to distinguish when it comes to something like leaf blowers, for instance, electric versus gas powered or battery operated? The reason I'm asking is when we first had sort of broached whether or not we'd go forward with a ban with leaf blowers, there wasn't a clear delineation about the fact we were addressing the biggest culprit, which was the gas powered. And so I had quite a few people who have electric saying, you mean I can't use a leaf blower at all? And I had to explain to them, no, our focus was more on the gas powered. So just to give some clarity to people, even though I know from what Craig said, we don't have the opportunity to deal with the noise for the leaf blowers, just a better understanding from people so they don't panic thinking that we're banning everything. That's just a suggestion. Thank you.
Thank you, Councillor Dunick. Councillor Lischina.
Thanks, Selena, for a great report. I need clarity, I guess. The draft bylaw, if you weren't recommending to go for additional public consultation, this would be the draft bylaw?
Through you, your worship, that is correct.
So I'm curious then, because when I went through the questions, there was huge support for restricting hours from 7 a.m. to 9 p.m., which is currently for leaf blowers, let's just say, to a 9 to 5 type of thing, and not including Sundays. So is staff saying that you're not interested in reducing any hours if this was the draft today? Like up to 40% said that they prefer reduced hours.
Through you, your worship. I think that's one of the things we're going to continue to look at as we go through and complete our public consultation. Definitely the draft bylaw is not written in stone. Okay. So there likely will be some changes as we move forward.
Right, because I mean, if we're looking at when leaves fall, which is October and October, November, I mean, it's 5:30 is sundown. So if we're going till 9 PM, which little kids are probably going to bed by 7:30 at that point, it just doesn't make a lot of sense to me. So because of that strong support there, I think we really should have a closer look at it. Thank you.
Thank you, Councillor. Councillor McNeese.
Thank you. Through your worship, I have a non-leaf blower question. Page 134 in the chart, just about barking dogs. So I see that, if I'm understanding this correct, the period of time is at all times. So I had a call recently, you know, someone leaves their barking dog in the backyard for copious amounts of time. So they would be able, through this bylaw, to call by law enforcement and somebody would come out, or is this existing? Is this already in place?
Through you, Your Worship, we currently have restrictions on dog barking. So really, it's that persistent nature of the dog barking that's the issue. So if a dog barks once or twice, it's really not an issue if they're trying to get in the house. But if it's sort of persistent over longer periods of time, that would be something that certainly municipal enforcement services could assist with.
So are there any, is this strengthening it in on page 134 in number E, where it says at all times, or is that existing?
Through Your Worship, that is existing.
Okay, thanks for the clarification.
All right, thanks, everybody. Councillor Shi has moved the indicated motion. Is there any objection? Madam Clerk, that motion carries. And the motion is that staff be authorized to engage in further public consultation to seek input on the draft noise bylaw attached as Appendix A to the staff report dated November 21st from Municipal Enforcement Services, and to report back with the final version of the noise bylaw by the first quarter of 2024. And thank you, everybody. Now, we have several confidential items, and I would like to know if I could get a mover for the Heritage Oakville Advisory Committee minutes and its recommendations. Councillor Giddings, thank you. Councillor McNeese, do you have a question? You're just volunteering? Thank you very much. Is there any objection to Councillor Giddings' motion? Seeing none, that's carried. Thank you very much. The decisions beyond the adoption of the minutes are that notice of intention to designate 3175 Lakeshore Road West be deferred to March 2024, and that the heritage permit application for 302 King Street be approved subject to conditions. And thank you, everybody, for that. And so now we need a motion to go into closed session for items 8.1, 8.2, 8.3, sorry, not 8.3. 8.3, as noted earlier, has been postponed. So 8.4. And the indicated motion is that these matters may be considered in the absence, so the motion is to go into a closed session for 8.1, 8.2, and 8.4. These matters may be considered in the absence of the public under Section 239, Sub 2 of the Municipal Act, because they deal with litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board, advice that is subject to solicitor-client privilege, including communications necessary for the purpose, and a proposed or pending acquisition or disposition of land by the municipality or local board. And the mover is Councillor Longo. Thank you. Any objection? Madam Clerk, there being none, that carries. And now we need a few minutes to deal with the technology and actually be in camera. And so I'm going to suggest that this is as good a time as any for a recess during which you can refresh yourselves. All right. Council has returned from a session closed to the public in accordance with the procedure bylaw and the municipal act to consider matters concerning litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board, advice that is subject to solicitor-client privilege, including communications necessary for that purpose, and a proposed or pending acquisition or disposition of land by the municipality or local board. And we have a motion, we have a set of motions coming out of that session, moved by Councillor Dudek, that the confidential staff report from the legal department titled Confidential OLT Appeal Barra Group River Oak be received, and that staff be authorized to proceed in appeals to the Ontario Land Tribunal filed by Barra Group in accordance with the report from the legal department dated November 14th, the supplemental report dated November 28th, and the memo dated December 4th. Is there an objection to Councillor Dudek's multi-part motion? There are two, and that means that the motion by Councillor Dudek carries. Thank you, everybody. There's a motion by Councillor Elgar that the confidential staff report from the legal department titled Unsolicited Offer to Purchase Town Lands, December 4th, be received. Is there any objection to that motion? There being none, that carries as well. Now, a motion to rise and report to council is in order. And I'm looking for a hand I haven't called on before. Councillor Shi, thank you. And is there any objection to that? Councillor Shi, your motion has succeeded. I rise and report the Committee of the Whole has met and made recommendations on consent items 4.1 and 4.2, 5.1, discussion items, I think they were 7.1, 0.2, 0.3, 0.4, and items 8.1, 8.2, and 8.4, and advisory committee minutes 9.1, as noted by the clerk. A mover and seconder to adopt the reports in order. Councillor Chisholm, Councillor McNeice, thank you. And is there any objection to the report? Madam Clerk, there being none, the report is adopted. Council, has anybody got any emergency announcements, congratulations, or condolences to convey? This is new business. Councillor Chisholm. Thank you, Councillor Chisholm, and I'm sure every one of us adds our congratulations too. It's a wonderful time of year at Christmas time and the other holidays that fall at this end of the calendar, and we all enjoy them. There being no one else with congratulations, I will ask for a mover and seconder for consideration and reading of the bylaws, and I'll accept that from Councillor Nanda and Councillor Lischina. Is there any objection? Madam Clerk, there being none, the bylaws are considered read and passed. And that completes the work of this meeting. It's been terrific working with you, and the meeting is over.